Welcome to Ask an Attorney, Florida Elder Law and Medicaid Planning.
Welcome to Ask an Attorney, Florida Elder Law and Medicaid Planning with John Frazier of Pippin Law Group PLLC. John Frazier is a Florida Elder Law and Medicaid Planning attorney based in Largo with advanced degrees in business and tax law and experience helping more than 3,500 families secure long-term care coverage. His practice focuses on almost exclusively protecting assets and helping clients qualify for Medicaid benefits the right way. I'm Evan Mack, and today we're talking about what you can legally spend money on before applying for Medicaid in Florida. John, welcome back, sir.
Thank you for having me today.
So, John, how does Medicaid in Florida treat someone who is over that asset limit and needs to reduce what they have before applying?
Well, in terms of expenditures, I think any legitimate expense or debt is permissible. Repaying mortgages, repaying car loans, credit card debts, making repairs to the house, property tax bills, property insurance, things like that. So I think any expense or debt is totally permissible to spend money on.
What types of expenses are generally allowed when someone is trying to reduce these assets before applying for Medicaid?
Generally, any current expense. I think one thing a person needs to be careful about is, let's say that you have condo maintenance fees every month, and then say that you want to prepay for a year, for example. I believe that there was an attorney who tried to do that, and the state of Florida Department of Children and Families said that that was not permissible because those monies could be returned to the Medicaid applicant and were therefore countable. And I think from an accounting perspective on a balance sheet, a prepaid expense is actually an asset. So you can really only pay current expenses and debts, so not future expenses.
Are things like paying off debt or medical bills typically acceptable ways to reduce these assets, John?
Yeah, absolutely. No problem at all with that.
How are home-related expenses like repairs, renovations, or paying off a mortgage viewed under Medicaid rules?
That's no problem whatsoever, totally legitimate, and I think that's a really good idea, actually. I did have one client spend tens of thousands of dollars on repairing the homestead, new roof, AC unit, furniture, basically everything. As long as you keep your receipts and document how you spent the money, that's no problem whatsoever.
Can someone use excess assets to purchase items, like a vehicle or other personal property? And if so, what limits apply?
Absolutely. One car of any value is exempt. So in theory, the person could go out and purchase an $80,000 luxury vehicle, and that would be permissible. And then automobiles 7 years old or older and not luxury vehicles, those are all exempt also.
So, John, what options are available for prepaying expenses like funeral or burial arrangements, and how are those treated?
That's totally acceptable. You can spend as much money as you want on a funeral service or cremation contract, as long as you make it irrevocable, meaning that you can't cash it in and get the money back. State of Florida is going to view that as an exempt asset. I believe I did have one client spent about $25,000 on a very elaborate funeral contract, and it was made irrevocable and therefore a non-countable asset.
So what kinds of spending tend to create problems even if the money wasn't given away?
Well, as I had mentioned, prepaying a future expense, I think that can be a problem. If you're thinking perhaps that you're going to go out and buy antiques or perhaps expensive jewelry, diamonds, things like that, that's not going to work. Those are going to be treated as countable assets. So you can really only purchase things like clothing, house repairs, anything you want to buy for the house, household items. I've had people buy cell phones, hearing aids, eyeglasses, computers. All those things would be permissible.
So, John, can you share an example of a situation where someone, tried to handle this on their own and it created issues with that eligibility?
I think we've seen a number of situations where people hear about the $2,000 asset limit, and then they immediately start transferring money to other family members. So that's highly problematic. You're only allowed to transfer money to a spouse, or if there's a child who's disabled, there are certain exceptions depending on the disability classification of the child. So you can give money to those individuals, but you really can't give money to anybody else. So that's very problematic if that's done within 5 years of the Medicaid application, especially if it's a large amount of money.
So, John, to kind of wrap things up, what types of financial moves most often lead to delays or complications getting approved?
I'd say giving money away is problematic, especially if that money has been spent and can't be returned. That can be a big problem because we are dealing with the state of Florida. They've got all the power. And so if they say you got to return the money to obtain eligibility, and then you take the position or the family takes the position that that money is gone, the state of Florida is able to just deny that case for a number of months, depending on the size of the transfer. So I think you've got to be very careful about that.
Oh, good stuff. John, thank you so much.
Okay, thank you very much.
That's it for today's episode of Ask an Attorney, Florida Elder Law and Medicaid Planning. If you have questions about Medicaid planning or want guidance on how to reduce assets properly before applying, you can visit estatelegalplanning.com to explore free resources and schedule a consultation with John. Thank you so much for listening, and don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode, and we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.